My apologies, you guys. The video cut off. I don't know if I'll be able to merge this or not, but like, share, subscribe to the mix. Like, share, subscribe to my channel. For a new trial was filed by the Tory Lanez attorneys. Improper omission of evidence. Omission of Exhibit 40A, the Shade Room Instagram. I went over this in part one of the video, and I didn't go over it, but I skipped over it really and skimmed through it because it just disgusts me. So I'm not gonna even go over this. I'm gonna go to the next era that Tory Lanez attorneys pointed out because this is one of the eras, and that's the shade room evidence. So yeah, and they did a lot of case citation in this. Uh, Page 23, hearsay. Oh no. My bad. I skipped one. The discovery violation amounted to a miscarriage of justice. That's page 20. Discovery. Something was going on with discovery, which was a violation, which was a miscarriage of justice. The instant case is okay. Here's the paragraph. Regarding ownership, the author and reposter claimed that the firearm used in Pete's shooting belonged to the defendant. Defendant identified defendant as the owner of the firearm by stating that investigations matched the bullets from his gun to the bullets to Megan's feet. Additionally, the shade room, explicitly said that the firearm was Tory Lanez's gun. See Exhibit 48. The people offer no evidence on the issue of gun ownership. What? Thus, the Instagram post was crucial. Man, here we go with the shade room shit. Excuse my French. Mm-mm. Any court look into the shade room, you have to conduct your due diligence. Period. Any court looking to social media, please conduct your due diligence. Period. Get affidavits, sworn affidavits, all of that to substantiate that particular post from either the shade room or whatever social media platform. That's just common sense. I don't get it. That's just common sense. I'm not gonna even go over that. Okay. The post amounts to inadmissible and inherently unreliable hearsay. So they went over hearsay too. Hearsay was an error, not subject to any exception. Should they go over hearsay? Uh, Hearsay. Mm-mm. That was another error. The hearsay. And then they pointed out hearsay again. The hearsay evidence was improperly introduced through expert testimony. It says here, this is page 32. In this case, not only was the information presented in the Instagram post inadmissible, so they reverted back to the shade room hearsay, but post inadmissible hearsay, but its admission through Detective Eberhardt's testimony violated established case law. And then they go on to quote case law sites. Then on page 33, it goes into here, Detective Eberhardt was called to testify and presented his credentials to the jury as a 22 years experienced officer and 14 years experience who in his investigation looks to social media, including Instagram, as an investigative tool. Based on his experience as a robbery detective, he testified that the blue check present on an Instagram page is a verification badge, meaning that the Instagram has been verified. That is an authentic account that belongs to, say, a public figure, a celebrity or athlete, or a particular brand, etc. Well, it's changing nowadays. Everybody can get a check mark. You get a check mark. You get a check mark now. But yeah, it's true though. You pay for it. Okay, page 33. The people then asked Detective Eberhardt to read the hearsay statement in open court, Detective Eberhardt testified that in response to the hearsay statement, people saying Kelsey shot her, Tory Lanez account responded, "That's not true." Based on the presence of the blue check, the contents of his Instagram account, and the totality of the circumstances in this investigation, Detective Eberhardt opened it was very likely that the account belonged to Tory Lanez or Mr. Peterson, the defendant, whom he identified in court by testifying to the credentials and experience as a law enforcement officer with specialized knowledge in using social media in investigations and being permitted to offer an opinion based on his experience. Detective Eberhard was an expert witness, and then they go into another citation because it related to defendant and the shooting in the question. The particular events and participants alleged to have been involved in the case being tried without having any, and I'm skipping around you guys, any personal regarding whether defendant was the actual author. The officer couldn't totally affirm that the defendant was the author because there are, like, I can get my son to post or give him access to my YouTube account and he can help me with it or whatever. So no one knows if that's really me or not making updates or publishing content or responding to comments. It could be one of my kids. Hint, hint. It could be, though, if I give them access, or we never know. So that's a good argument. They go, so another argument is these errors of law pertaining to evidence introduced through the Instagram posts related to resulted in miscarriage of justice. They going over more Instagram crap. I just can't believe they used a lot of Instagram. This is total wow. Okay, then they go into violation of defendant's right to counsel. That's the Sean Hawley. She is a female attorney, and he was facing charges. He was formally the people defendant. Yeah, I kind of went over this the first time, like kind of skipped over. And then also another issue that they raised, the prosecution prejudicially interfered with defendant's right to counsel. That's another error. It was Deshaun Holly. And it goes into that. The prosecutor's action deprived defendant of conflict-free counsel. Wow, they really interfered with his. Oh, the DNA evidence. This is, I guess, the good stuff. Evidence admitted against defendant fails to comport with industry accepted standards in violation of the defendant's due process rights and resulting in a miscarriage of justice. A trial, the people introduced evidence that the defendant could not be excluded as a contributor to the DNA evidence collected for the firearm recovered in the SUV, though his profile was conclusively excluded as being person in the magazine. Wow. Oh my gosh. I just, I ain't gonna go over the rest of this. You guys, this is page 45. It's 84 pages. This page 45 about the DNA. This is, ooh, ooh. Free Tory Lanez, free Daystar Peterson. This is definitely a miscarriage of justice. It really is. It really is. Um, the DNA evidence was inadmissible. The erroneous admission of the DNA evidence amounted to a miscarriage of justice. Oh, wow. This is really interesting, you guys. It's a lot to process. It definitely is. Improper admission of defendant's tattoos. Oh gosh, yeah, I think I kind of skimmed over that the first part one of the video. I didn't understand that. Everybody has tattoos. That doesn't mean that that person is acting out what their tattoo, the art on their body. This is admission of page 75. Admission of defendant's tattoos and rapplers. That was another one. Yeah, this was wow. Defendant's right under Constitution clause were violated regarding Harris' testimony. Oh, that was Kelsey Harris. Okay. The confrontation clause of the Sixth Amendment to the United States Constitution provides that the accused shall enjoy the right to be confronted with the witness. It is guaranteed in California, blah, blah, blah. And in cases where here we go. Here, when Harris invoked the fifth, oh, there you go, there you go. When Harris invoked her Fifth Amendment, yeah, privilege against self-incrimination, she was thereafter offered immunity and recalled to testify under protection thereof. She nonetheless refused to cooperate with the people's case to the point that, yeah, this should have been thrown out. They going into, man, Judge David needs to, this page 77. This is what I was looking for. The Kelsey situation. I said off of this alone, I just knew it was going to be like a mistrial. I promise you guys. I just knew it was going to be a mistrial off of Kelsey doing what she did. I just thought it was going to be a mistrial. It's a mistrial or hung jury or something, whatever. Wow. Yeah, just off of this alone. His attorneys make some strong arguments, legal arguments, you guys. That was page 70, I think 77, about the Kelsey situation, which that does violate him, his right. Oh my gosh. Whew. So drop a comment, you guys. Like, share, subscribe to the mix. Like, share, subscribe. This is part 2 um, of the motion for a new trial filed by Tory Lanez attorney. And remember, you guys, this motion is going to be heard by Judge David, the trial judge. And if Judge David denies this motion, then that's when an appeal will be filed. So, yeah. What sentencing, I think, is April 10th, they said. So, I'm inclined to think or to possibly believe that Judge David is going to rule on this. Wow, Monday, the 10th. He's going to rule on this during sentencing. Man, ooh, prayers up for Tory Lanez. I pray, y'all. I do. Because this is just clearly and I'm speaking through perspective, legal perspective. But like, share, subscribe to the mix. Like, share, subscribe. Drop a comment. What are your thoughts? Part 2. This is part 2. My focus was on the Kelsey situation, and it came up on page 70. What? Let me go back to this. I printed out all 84 pages, you guys. I sure did of this document. I think the Kelsey situation. And like I said, I thought it was going to be a mistrial. Like, it wasn't going nowhere after that. Yeah, page 77. Kelsey's situation came on page 77 of the motion for a new trial document. That is another legal error. His attorneys cited so many legal errors, and I'm quite sure they could have went on and on. It could have been more than 84 pages, you guys. 84 to 85 pages. I'm telling you. But prayers up for Tory. I hope that he will be granted a new trial. I hope and pray. Prayers up. Like, share, subscribe to the mix. Like, share, subscribe. Again, this is part